because I am honored to be here, and it's always exciting. I would do this for one person or 1,000 people, but it's always exciting to see a room that's filled, and also to see a lot of young faces too, because this is a really important and impactful issue. And so, as Professor Bartel said, it's great that you're here to be able to take it in. And it doesn't matter if you've taken copyright or intellectual property before or not. I'll kind of hit the high notes, but we will get into the meat and the substance of 203 terminations. I want to take first opportunity to thank Professor Bartow and everyone at the Franklin Pierce Center for Intellectual Property and the invitation, for the invitation, and to thank you all, particularly my future colleagues, certainly future students, and the family here. It really makes a difference, and I really feel it. You have something really, really special here. And so I'm honored to be a part of it come this fall. I also want to thank some attorneys who sewed into me as I was preparing my remarks today. It's one thing to be buried underneath dozens or hundreds of law review articles as you sort through to prepare a paper, but it's another thing to connect directly with practitioners who are also, actually our boots on the ground to figure out like what's really going on. We can theorize about what might happen, and I will talk about that later in my remarks, but it's always critically important to connect that theory to the actual practice, and so we can then talk normatively about what should be and forecast what might be in the future. So I'd like to thank Lisa Alter from Alter, Kendrick, and Barron, Brian Kaplan in New York, Kevin Gold and Todd Schill, both graduates from Widener Law Commonwealth who are doing big things in the great state of Pennsylvania, actually. They just formed a new firm, and part of it is a substantial practice in entertainment law and intellectual property. So they were very helpful. And also a dear friend and colleague for many years, Lloyd Jasson in New York, who practices in publishing law. And all of them are involved in issuing notices and the negotiation that goes forward. So it was critically important that I pick their gigantic brains to try and figure out and make sense of what's going on in the industry. And so I'm excited, obviously, to share my insights with you today and the emerging research that I'm working on. I see this very easily turning into some type of empirical analysis over a period of time. How many notices are out there? How many people are doing this? What's the actual impact? And so that'll take some time. So I'm really hitting the high notes today to at least bring to your attention some of the issues that are percolating just beneath the surface. There are actually two types of termination rights. As you may know, if you've had this course before, you practice in this area, or you write about this area. I'll be focusing on 203 termination rights, but there's also another termination right that applies to pre-1978 transfers, and it's quite dense and nuanced, and so this talk and the focus of my remarks today is really focused on what's happened as a result of the 203 termination window opening up in 2013. All right, so because we have is this for me? I'll save this for later. All right, I won't presume, we shall see. All right. And so we will have, because we have a rather broad audience, both in the classroom and also through the live stream, I'm going to focus briefly, very briefly, on what copyright is, how it's created, what specific rights are involved, how it's transferred to make sure that we're on the same page. And then I will move on to the meat of my remarks to talk about 203 terminations, the history and the purpose, the intent, the congressional intent behind where, or the origins of the termination, right? And specifically the mechanics. This can be really tough stuff. And it's critically important because it's the type of right that it's use it or lose it. And so to be able to advise clients and to really fully appreciate the mechanics of it, we'll talk about the timing. There are actually some really good resources out there on the great interweb as well that will show the relationship between the dates, a termination notice, that period of time to effect notice. And so we will really take a look at the mechanics of issuing notices and actually effecting termination. We'll talk about the anticipated impact to the industries, the copyright-rich industries. Of course, the entertainment industry is an important part of that, but it's not the only one. It's the sexy one that I get to talk about and take great photos of, but it's certainly not by any stretch of the imagination the only one. But most of my writing tends to be in the entertainment space, and so I'm going to use those by way of example. And then we'll talk a bit about the actual impact based upon some of my conversations with, again, practitioners in that space. And then we'll talk about what the future might hold. So the folks that I spoke to certainly had their ideas, and there was a lot of similarity in terms of where we are and where we're going. And then I'll just make some conclusions that don't necessarily have an answer. Obviously, we're not there yet, but hopefully they can set the stage for future conversations. And so the copyright overview, how it's created, what it protects, copyright transfer, it's actually defined in the Copyright Act, and then distinguishing briefly works for hire, because works for hire are not contemplated or protected by a termination right, and we'll talk about why. Copyright. It is a federal right that's statutorily prescribed that protects literary or artistic works that are fixed in some tangible medium of expression. So the idea of a poem, for example, is not something that could be protected by copyright, but once it's fixed in a tangible medium, on this old thing called paper, in a computer, once you record it, and presumably it's capable of being copied, it's sufficiently permanent, then rights attach automatically. There's nothing additional that one has to do for those rights to attach, assuming it's proper subject matter of copyright. There's certainly benefits to registration that's outside the scope of what we're talking about today, but those rights exist in that fashion. Section 101 of the Copyright Act defines transfer as an assignment, mortgage, exclusive license, or any conveyance, alienation, hypothecation of a copyright or of any of the exclusive rights comprised in a copyright, whether or not it is limited in time or place of effect, but not including a non-exclusive license. And that's important as we look at what it means to transfer, as we later talk about how to terminate those transfer and reclaim copyright. Copyright termination. So I will talk a bit about the history and the purpose of the termination right, so we can figure out where Congress was going in 1976 as it updated the Copyright Act from the 1909 version. Briefly, how the 1909 version worked, and we particularly have to focus on the renewal rights, because that really is the precursor to what we now know as the termination right. So before 1976, Congress attempted to protect authors. This has a protective, somewhat paternalistic, some might argue, but certainly a protective function for authors who would assign their rights through a two-term system that created an initial term of copyright and then an automatic renewal. The idea behind the automatic renewal is, we can't really value copyrighted works in the beginning. I write a manuscript, somebody buys the right, I transfer my rights. We have no idea if it's going to be something we've never heard of or Harry Potter. We've no idea until time passes on and the market reacts to the works. Some things are evergreen, some things have a season, some things never get there, most things, right? And so the idea, particularly if you are a first-time creator, how does one value in this quote-unquote arm's length transaction? And so the idea was people who are entities that are situated to actually exploit rights. And when I use the term exploit, it's not in the exploitative connotation, but to successfully monetize or maximize the value of a work. There are industries that are built on this idea of being the gatekeeper. So the bargaining power at the table is not at all imbalanced for a first-time creator. Maybe after I've written Harry Potter, I come back, and now we're talking, right? But before then, we don't have much to talk about. I'm deliriously happy that you signed me. 99 other places said, no way, right? And so the idea of going to the table from that point of view and perspective is tough, particularly given how long copyright lasts. Now, the duration of copyright for a person who has created something on or after 1976, life of the author, with the extensions, life of the author plus 70 years after the author's death. That's a long time to sit down at a table and say, I'm going to sign my rights away. I have no idea what the value of this is. And so behind that, even before the 1976 Act, Congress says we have to do something about that. So we have this initial period under the 1909 Act, and then we'll get this automatic renewal. And the idea was they would go back to the table, either work with the same transferee, or maybe they would go at it alone, or find a better deal elsewhere. It didn't work in practice that way. In practice, the transferee said, we'll take that initial term, and oh, by the way, we're going to take that renewal too. Thanks, sign here. And without the ability to avoid that, it was a right without any real impact. It truly was illusory. It was truly all hype, to stay with the theme of the conversation today. And so the intent in 1976 was to avoid that right. There was a lot of stuff going on in there. So this is a dramatic oversimplification, but once we moved from a two-term system to a single unitary system of copyright, the idea is we'll have this term, but we also create a right to terminate. There's a lot of back and forth and negotiating the nuances of that. Obviously, there was a lot of pushback from industries, and so instead of being automatic, now it's an affirmative right, something that someone has to actually do something in order to secure it. So that's kind of the intent behind the termination right. And so moving on to the summary of the law, Congress basically empowered authors to reclaim copyright after 35 years. So decades have passed. Presumably we understand better the value of the work, and also the idea that the termination right is non-waivable, it's inalienable, and it's also, but it is inheritable. That's not the subject of this talk, but I have some extensive research around the idea of what happens when a statutory heir steps into the shoes of an author who dies before they have the opportunity to actually exercise their termination right. And that's a huge topic today as well, so do pay attention to that. Not just the ability of the author, but the statutorily prescribed heirs who could also step into the shoes to affect the termination right as well. So non-waivable, inalienable, but it is inheritable. So we have the right, and the ability or the window of time for an author to effect termination begins 35 years after the transfer. We know that it's inalienable, non-waivable, et cetera, because of this specific language in the Act. Termination of the grant may be effected notwithstanding any agreement to the contrary. So it doesn't matter that author sits down and signs away their rights throughout the world in perpetuity and then some, right? This right exists. The problem, of course, is if they don't know about it, and we'll talk a bit more about that later, about what's happening today and what might happen in the future, but assuming they know, this is clearly an incredibly powerful right that says no matter what I said and what I signed, I can come back later and reclaim rights. So let's talk about the timeline and also and make a little more sense of the sausage here that you find in 203. So this kind of lays out the timeline, and I want you to pay attention both to the notice window but also the termination window. And then I'll give you an example and we'll kind of play it out. Assuming we have some work that is created on or after January 1st, 1978, the person will have the first opportunity to terminate 35 years after that date. All right? And so you see the plus 30, does this have a thing on the end? No. If I were, and you could see 35 years after, hopefully you can see that, that would be the earliest that someone can terminate. 10 years before that is actually the earliest that you could serve notice. And so that's why on the bottom we have the 13-year notice window. The earliest that you can serve is 25 years before. The latest is 38 years after. All right? And the reason is notice cannot be served earlier than 10 years, nor later than 2 years before termination. And so effectively that creates a 13-year window. Has to happen, you know, if you're gonna wait all the way to the 40th year, it has to happen in year 38, or else before year 38, or else it's forever lost. all right? And so that's how it works itself out in a dramatic picture fashion. But you can imagine that at this point, you might not imagine, actually at this point, some people have already lost their opportunity. And so we may actually start seeing some malpractice suits where people say, hey, now, what was that you said? Or didn't say? What about my rights now, that I should use them or lose them? This could be a problem. So from an ethical perspective, this is a great consideration that practitioners are seeing now, where someone wakes up, reads about Victor Willis from the YMCA, went to karaoke one day, read something, and all of a sudden it's like, wait a minute, the rights that I transferred in 1978, I've already lost my opportunity to serve notice and to effectuate a transfer. So the forecasts and the concerns. There are a number of different things, and so I have some of the quotes either from folks that I've spoken to, and this is just reflective of all of the information out there. They basically show what most people think or say, be it commentator, practitioner, industry, stakeholders, and the like. So what did we think was going to happen before 2013? That the termination right would have significant implications. I should have bolded them to make them even more dramatic. Significant implications for the entertainment and publishing industries. It's always described as this looming battle. There's some great imagery of, David versus Goliath, that type of activity, and take back the night and coming back for my rights, right? So it's the idea is really going to turn the industries that depend on copyright ownership on their ear. The already struggling, and I do that with air quotes, music industry is still a little well off, just not as well off as before when we were all buying CDs. But I think they're still doing okay, right? But there was great concern. What happens when all of these artists come back to actually effect termination notices? What are we going to do in the industry? The fact that it would dramatically impact, and I loved what Richard Bush said, it was going to be Judgment Day. It was going to be the reckoning of folks who are really coming back to take back their rights. And it's understandable, because when we think about the power of this, again, assuming that artists know, and authors, and when I use the term author, I'm not just talking about those who write, but the broader definition under the Copyright Act, that it could have had that implication. We haven't seen it play itself out that way. No major publishers have shut down their operations, for example, but certainly the industry, as it continues to change in other rights, is certainly considering this. This is now a consideration, and probably that's the way it was supposed to be. So the actual impact, what people are saying about what's happening in practice, artists have and will continue to send termination notices. There's a lot of news reporting around some of the bigger celebrities, certainly Prince. I can't even go there. We want to talk about him. Loretta Lynn. We'll talk about Loretta Lynn, Tom Petty, The Boss. There are a lot of artists who have successfully reclaimed their rights. And the first, they kind of led the way, really the first test case, and you may have already heard, and I certainly have mentioned it before, Victor Willis. I don't have his little picture there, but we have Village People. I think that name is more recognizable than Victor, but he doesn't care if you recognize him. He has his 33 copyrights back, so there's that. All right, so the idea of empowering someone, actually he's a really great example. He's almost better than the rest as I talk out loud, because this is someone back in the day who, was relatively unknown except in the context of the group. But he co-wrote most of the hits, right? The YMCA and the like. And so the idea that he could come back, he really is a wonderful poster child for the example of how powerful this is, to give him a second chance at a career. And he might not be out there performing, he might be, bless his heart, but the better part of this is that he's getting some checks. Right? And that is really what it was all about. So again, I think he really is one of the best examples of the power of the termination right. So again, a bit more about the actual impact. I've said this earlier, but no major publisher has gone out of business. We don't see music distributors and the like closing down and shutting down operations as a result of termination notices. The film industry isn't going anywhere. There's a lot of activity and action with respect to notices in that area as well. But again, nobody's shutting down their doors as a result of receiving termination notices, although some big ticket items were at risk. You've seen even before or after things like Superman, Marvel Comics, Lassie. This is under the previous iteration, but still they're great examples of properties that were extremely valuable. And a number of others. We have some very valuable catalogs, some of the Beatles stuff that is coming up, and so there are a lot of valuable properties, but still the industry continues. What happens the majority of the time is authors resign. They resign with the transferee. But during that time between notice and termination is when parties are forced to the table to say, now about those rights, you did well. I did okay, but you did well. Let's renegotiate. And so the idea of the congressional intent of the termination right in that fashion works ideally. That's optimal as they try to force a particular result in the marketplace, where the parties come back together and they renegotiate on better footing, for at least from the perspective of the artist. And obviously, we're not going to do this unless it's a successful catalog, for example, right? So it's win-win in the sense of how can we continue to work together. And also, most artists or authors are not in the position to successfully exploit. That has changed a bit because the internet and digital technology has leveled the playing field a bit, and certainly for an artist of some note or measure may be able to go direct to consumers and take out the middleman, and that's a possibility. But what practitioners are telling me is that many authors or artists end up resigning. Others just successfully, they wait out termination. They said, it's been nice working with you all those years, or not, and we're just going to have a conscious uncoupling, and I'm going to go on with my life, right? And so they wait until the rights terminate, they reclaim, and then they sign with someone else who they think is more well-situated to exploit the rights, or maybe they have a better deal. Maybe they didn't get a signing bonus from the last one, and so maybe they have a signing bonus and some type of better royalty escalation or something of that nature. And then others do reclaim. Maybe they are in the position to actually exploit the rights on their behalf. They go out, they get an administrator to administer their copyrights, and they go on without signing some intermediary. So those were always an option, but it is interesting to note that most choose to stay with their current transferee. And maybe transferees proactively step up to the plate and say, I've loved working with you all these years, let's do something, again, that's win-win. So in that regard, again, if you think that is the proper result, then it's good for the marketplace. What the future holds. So we could go on and on and on. I could have slides and slides about what we think might happen based upon the bit of what we know now since 2013. We will certainly see more of the same. So we will see a continued stream of terminations, and as there's additional press and maybe more success and maybe some unsuccessful terminators, then people will become more aware of their rights. And I think that's what our role may be, is to continue to write about it, to continue to talk about it, to continue to present about it, and raise the awareness. Certainly, we have author and artist unions who have been talking about this for years as well, but that doesn't necessarily mean that it will actually trickle down. And when we think about the nature of creativity above and beyond the big ticket item of the entertainment space, anyone who is creating literary or artistic works and effects a transfer, whether or not they are well-known, still has access to and the advantage of this right. So think in the tech space and the innovative space. We might not be signing with big music moguls, but a transfer is a transfer. And the inability to value on the front end remains the same in many instances across any type of creative work, right? And so we have to keep this at the forefront as you go out to represent clients, to make sure that any client that comes in, whether they're a major artist, an up-and-coming artist, a small business person, a tech startup, that they understand and appreciate the nature of their copyright And so they're able to leverage that either on the front end or certainly on the back end when effecting termination. I mentioned this a bit earlier, this idea of malpractice suits against lawyers who didn't fully apprise or apprise at all their clients that the termination right was a thing that would have to be entered into a tickler file so that when these notice windows open up, that they take full advantage. And so at least 2 of the practitioners who I've spoken with have been involved in such things. Not them, they're representing people, let me not mistake, but I told you who they were too. Not them, but people they know, all right? And so that certainly could be a thing as well. 3, I didn't mention a lot about it, but there is some literature out there, and I have written about loan outs and the impact the use of loan outs by artists to have tax advantage, business advantage, where they'll set up a corporation. They're both basically in charge of the corporation. They will, if to the extent they have created artistic, creative works, they may transfer it into the corporation so that the corporation owns it and they don't own it in their own right. So it removes, it gives them some limited liability, tax advantage, bada bing, bada boom. But once they start creating in the context of the loan out corporation, anything that is created in the context of employment is a work for hire. It's not a transfer. The transfer right does not apply in the case of work for hire creations, which means that I know, creator, you have created it, but you've done it in the context of employment, or it's part of a commission, especially commissioned work that has a specific definition in the Act. I think it's 9 different types of specially commissioned works, and a writing at some point that says, oh, by the way, this is a work for hire. So it could be in the independent contractor space, but it certainly is in the employer-employee space. So those creations within the context of the loan out actually aren't subject to a termination right. And what if that loan out corporation then has to transfer it out to a company, right, or a transferee? It's no longer protected by the termination right. And the question is, what do we do about that? What was the intent? How's that going to play itself out? And so some really good articles about this. There's a Harvard Law Review article about it not too long ago. I apologize that I can't remember the author of it. But that is a really big part of what do we do about that. There's some other gaps, issues about protection. There's a recent thing that I'm still unpacking about the implications of U.S., this is not up here, but I'm constantly updating and researching, and Duran Duran. Who knows Duran Duran? All right, excellent. And Bruce Springsteen, everybody? Oh. Paul McCartney. Beatles. Ooh, you guys don't go to karaoke or anything, goodness. So basically what's happening, the question becomes, what happens when someone terminates rights based upon United States copyright where there's some contract for it in the UK? An effective termination here in the States may actually be a breach of contract under UK law. So Paul McCartney has filed a declaratory case to figure out what's going to happen because I'm doing this. I'm getting those Beatles rights back, my interest into them, but I don't want to do that in the United States and then have a deleterious impact in the UK. What does it mean? We don't know the answer to that yet. It's likely that it won't have the impact that it appears to under this Duran Duran case, but it's a thing. And it's something that is happening in real time, and so you should keep your eye on that as well. The final thing is that is on the slide is the greater emphasis on preparing derivative works. What I didn't mention earlier is transferee during the term of the transfer can also, to the extent that it was a part of the deal, prepare derivative works, something that derives from the original, an adaptation. So maybe we're talking publishing company, they bought the rights to print, but also they have all of the rights, including the right to adapt, right, to create a movie based upon the book, for example. After termination, that original transferee can still exploit the rights to any derivatives prepared. And so maybe the industry response is, okay, we see the writing on the wall with respect to termination, but we are going to adapt the heck out of this thing, right? Because they will continue to control those adaptations even after an author successfully terminates. And it may be so substantial or significant that those adaptations or derivatives created by that transferee actually may be in direct competition with some line or space that that original creator may want to fill. So as a practical matter, how is that going to turn out? And we don't know, but we see a lot of things that are prepared as derivatives just before, remarkably, the copyright is about, or is about to expire. We see more Mickey Mouse stuff. We see Chips is coming back. I don't know why. Like, all these things are happening, right? It's like, that's curious. There's so much awesome, good, new creative stuff. Why do we see the same 9 things? Oh, copyright, right. Right? And so the idea that maybe they're just going to have a greater emphasis on preparing derivatives instead, and then fully exploit and monetize that and continue to do so after the effective date of termination. And so a few conclusions, and then I suppose we'll take questions.
That's okay, sure.
Sure. So I posed the issue at the outset about whether this was all hype or finally ripe. I think it's safe to say that this is definitely not just hype, that this is going on, that it's an important aspect. It hasn't been the termination apocalypse that we feared, but it is certainly happening. And so to be able to more fully understand and appreciate the impact and how to successfully represent clients in the space is going to be important, not just today, but for years to come. Is it right? It's absolutely right. We talked earlier about the fact that for some who transferred in '78, for example, that ship has sailed. And so this is definitely timely, both again now and in the future. It appears to be functioning as it originally was intended, that it forces parties back to the table with presumably a different bargaining position and basis where the author does step back into some type of power or maybe steps into it for the first time. It serves, it being this notice period, both a stick and a carrot to negotiate for better deals, either with the current transferee or to seek other deals or other opportunities to exploit. And finally, this is an unbelievable niche. I was pouring through a number of the cases, some of the most famous or almost now infamous cases in this space, and it was like one guy who was like representing everyone. How's that fair? No, I don't know. He's expertised himself exponentially. And so there's a lot of room here. It's very tough, nuanced, complex, sophisticated stuff. You expertise yourself in this area, you've got yourself a career, right? And so it's a great place to focus your time and attention. And even if you don't practice in this space, it's also important to know enough about the issue or the topic that it triggers you. I need to farm this out. I know this is a thing. I am not the one for you, but I know someone who is. And that adds value to your practice as well. So be sure to be mindful of at least being able to spot the issue. And with that, we will take questions. That's me. And again, thank you for your time and attention, and we will take questions.
So could you talk a little bit about the litigation that Willis, the guy, had to go through? Because that's, I think, the most scary thing from my standpoint, that artists don't benefit from this, is that they're buying into this huge lawsuit because the music, most of the big entertainment companies can litigate the artists into the ground. And if that happens, then the whole point is lost because most artists can't get involved in that. They'll just capitulate.
That actually happens a lot too for the practitioners who I spoke to. It seems that, you know, whoever they're working with are people of means, or at least they're willing to have some savvy means of the fee structure and things of that nature. But most people are not going to do this. They'll get buried in paper. It costs a lot of money to pursue this. So we're talking about this if it's this great thing, but in practice, if you don't have the proper socioeconomic condition to be able to take advantage of it, it's as if it doesn't exist. One of the most important things in 2012 for Victor Willis, one was even if he was in a position to sue, which you could litigate for years just to determine whether someone has proper standing, and then you'll get weighed down with whether or not you properly gave notice. There are a ton of cases in that regard. It's like, yeah, well, this termination thing is a thing, but you didn't do it right, correctly, even though there's no standard form, but the timing matters, and the standing matters as well. And sometimes everybody doesn't participate. So what happens when you have one person who says, I want out? I'm a 1/3, or I think in his case, he was either 1/3 or 1/2. Third, so I want my 1/3, I don't care what the rest of you do, right? And so what happens in that regard when others don't want to follow? He can successfully acquire his 1/3 interest, but that still is not a win-win necessarily. And it costs a great deal of money not only to sue, but then to administer, then to follow up, then to do the proper accountings. So this is not a one-stop proposal. This thing goes on and on and on when you don't have willing parties at the table, and he's an excellent example of that as well. Questions? Yes.
You talked a lot about how artists are just re-signing with the studios. Do you think with Spotify, Apple Music, and Tidal, like I know Prince wanted all of his music at Tidal, Chance signs exclusive deals with Apple to stream it 2 weeks only. Do you think a lot of artists will terminate and then just license or just sign exclusive deals with the streaming services instead?
I can see that happening too, but you do have to be an artist of a specific level for it to really hit, because if we're selling things, if we're selling licensing, streaming is licensing. I don't know if you know, but we don't own any of that. I mean, I don't do that, but for those who love to stream, and then one day it goes out of business and you don't know where your catalog went, it's because you were licensing it, not owning. And so it's an excellent revenue stream for artists who can successfully exploit that. Chance the Rapper is an excellent example of that. He's not even signed. So we just have to watch him just be amazing, like for the duration, because he had the opportunity when you're selling things out of the proverbial back of your trunk, right? Whatever that looks like now in the 21st century, and you have your own following, you make the rules. You really do change the playing field. And even if you're not an artist of that level, you can still have benefits, but he'll have tremendous benefits, because not only is it about streaming and those exclusive licensing opportunities that I think I see them serving themselves well, but Prince is a great example too, and even some of the Beatles music. I remember this, the whole thing of whether you can access it on iTunes and it wasn't there, how do you find the music? So we are still in the midst of a dramatic change or shift in how to monetize music. But for those Chance the rappers of the world, they are gonna definitely choose that option, because everybody is calling him and he's not taking that call anymore, right? And he doesn't have to. So it's a good example. Saw a hand, yes.
So with the entertainment industry being so monolithically owned, if an artist and a publisher had a messy divorce, how affected could they be by, you know, that YMCA song? That'll never be a 20th Century Fox movie ever again. That'll never be, like, is there any thinking about how that's going to affect? I think about like Disney owns ABC and so like, you know, there could be some really serious implications if you had a.
I love that question, because the point is well made. I mean, you really have like 5 companies that own all of entertainment. Absolutely.
And publishing.
Absolutely.
Yeah.
And so the idea that if you don't play ball, okay, you take your little rights back. But this will never be synced in a TV show. There will be no opportunity. You will never see it in a commercial. I can absolutely see the strong arm nature of that, because the industries have to respond in a way that makes sense for the bottom line. And they're always going to do that. And so I can imagine that happens now, even without having to contemplate the termination issue. But it would be interesting to see what happens. There are a lot of private, this is the other thing that came up in the conversations. Much of this is private, because particularly in the music industry, nobody wants to be this test case. Nobody wants to be, they have evidently had enough over the last 20 years that they really don't want to lead the way for litigation in this space. And so there are a lot of private agreements, which is going to make an empirical study even better, to the extent I can get that information, because it's not public record. But there's a lot going on, and probably a lot of that wrangling at the table that we just don't hear about. Questions? Sir.
Yeah, I was just wondering if the statutory errors, if they could bring up malpractice suits against, you know, the attorney, saying that if the, you know, grantee was still alive, you would have wanted to terminate?
I can imagine, because what happens is statutory heirs will, I don't want to say step into the shoes, because sometimes people argue that for a statutory heir, it's a separate right. Even had to wrangle with that in my own scholarship. But to the extent that someone dies without first exercising their right, statutory heir steps up, is an interesting question from an ethics perspective when you're missing privity, right? So we have to remove that bar, and we see that in some spaces about, all right, we know technically speaking we have to have privity, and if you don't have privity, I'm sorry, heirs, that this didn't work out for you, but you weren't, in privity with this attorney, right? So there's a lot of there, but we have seen cases that said we're going to remove that as an impediment because underneath it, but for the ability of these heirs to step in and do that, there would be no true protection. And so that's a great ethical question to wrangle with, to see if this would be one of those exceptions where we might remove that bar. Other questions? Yes.
Have you seen any variance in termination in the different fields of copyright, whether it be music, writing, or film, that kind of thing?
I see it, and I know publishing better than the other spaces because I've practiced literary law for years before I started teaching. And also there are special rules if you have the transfer of the right, but the publication of a book, for example, is delayed, and that happens all the time. Writer signs a deal, transferring their rights, and the book is not published for 18 months. Or 3 years, or if it's fewer than 5 years, same rule applies. If it's longer than 5 years, then the 5-year window is what it is. And so in that space, it can be slightly different. And I didn't drill down far enough for purposes of this presentation to see, are there substantial differences between film, music, and publishing? It's just by the nature of the folks that I spoke with, they covered the gamut. But that'll be an interesting question for me to follow up on as I compare and contrast going forward. So,
It seems to me that there's a real advantage for the companies to just keep quiet about this. Mm-hmm. So is there a part of the bar out there, like I almost expect now to see on late night television, was your dad in a band? Call us now. And especially the heirs, who I imagine don't even know that this is out there. So it's, where is this notice getting out? How much is this notice? I mean, it seems to, until you start talking about it, I don't think I thought about it or heard about it. Now everybody's looking in their attic for their missing documents or whatever it is.
I just think that you'll start to see more of it because the point is well made. We already know that most creators don't know about it, let alone the people who inherit the rights to the extent they know that they even exist. And then what do you do about them? In the estate planning space, and I teach wills, trusts, and estates as well, the idea of having an intellectual property trustee is an important part of estate planning. So you may pick someone to take care of car and real estate, but have someone completely separate who is savvy and understands the nature of intellectual property rights, generally copyright in particular, because of the duration of copyright that goes on. And in the trademark space, as long as it's being used as well, but my focus is really on copyright and what an heir is going to do, because it's not just talking about what do we do with dad's stuff, but now we have a right? That is different than just trying to settle property of a decedent's estate, but going beyond that and actually stepping in and having his or her own right as a statutory heir. So there's a lot of education that has to go forward. I think it really still starts with the creator, because if we can, in the general sense, if authors are more well-versed on the rights as they exist, then maybe that filters down into the people who are in the better position. I will use the example of the Ray Charles Foundation, though. Talk about, Ray Charles has had 13 children and basically talked to all of them before he passed and says, I have this foundation. The foundation is supported by royalties from my music. I want it to stay that way. So instead, I'm going to create irrevocable trusts for all of you, kick in some money, and I want you to have that instead of any rights that you may have down the line. And they said, awesome, Dad, sounds great. And then he passes, And then 7 of the 13 say, I don't remember anything I said, and I want those rights. Right? So they were savvy. They got a lawyer, and maybe they saw a late night ad, I don't know. But there are some. But I really do think that as it continues to be covered in the media, and then you have the bigger ticket, more sensational topics, that it will trigger people to say, what's this thing? I need to know more about it. Yes?
As attention gets drawn to this, are you getting any sense that Congress is going to do anything on the statutory side to change it in any way?
Such a hard question. Such a hard question. I have not heard. This is always something that's being discussed, but it was something where we're kind of kicking the can down the road because they didn't have to really worry about it. And I think only if the market response starts to deteriorate will there be any push from a stakeholder to do anything about it. So I can write about it till the cows come home, and I do, and to say how things should be, but unless it's corrective of the market, and if this is the way the market's going forward, then it doesn't seem to be broken, at least this part of copyright law. I think we will see an update of some copyright. It's time. It's time. We're not even going to write about it anymore. We're tired of writing about it. We're just going to let it happen. But as with respect to termination, I don't see any tweaking of it unless and until there's some market breakdown and then stakeholders come back to lobby. I thank you for your time. Oh, no.
So you talked about the Duran case.
Yeah.
And in that case, they contracted their U.S. copyrights in a U.K. contract and contracted away their
That's right.
termination right. And that's what Sony's saying Paul McCartney has to wait for because it's on appeal. Do you foresee, professor up there said, Congress addressing the conflicts of law there? Because
now there is an area where it could happen. We just have to see how I don't see it, the Supreme Court is not going to take it up until it becomes an issue, see some type of circuit split, or in some way it's so impactful that they have to speak. So they're just not, obviously they're not going to lead or trailblaze in that regard. But if that area breaks down, then that would absolutely be an area that would be ripe for some type of affirmative update, amendment around that specific topic, absolutely. Because then it contemplates the Berne Convention and all of these other things, so it's super complicated, but that absolutely could be an area. All right, thank you all for your time and attention. Thank you very much.